Hello friends, as part of my video lecture series, today I would like to explain one of the most important legislations pertaining to both the civil as well as criminal matters, that is the Limitation Act 1963. The Limitation Act 1963 was enacted by Government of India in the year 1963. In case of transfer of property, contracts, easements, the limitation in cognizance of certain offences, applications and appeals, every liar should know about the period of limitation fixed in the Limitation Act 1963. The Limitation Act 1963 is the only law which specifies the prescribed time of limitation for various appeals, various applications and various suits. The Limitation Act 1963 does not specify the limitation for cognizance of certain offences, but the Code of Criminal Procedure specifies the limitation, the time of limitation for cognizance of certain offences. However, in this video lecture, I have compiled those provisions. Let us discuss the concept of limitation. Limitation means a prescribed time limit according to a particular statute. Here the Limitation of Act 1963 is the statute, it is the legislation. The limitation means a prescribed time limit according to the Limitation Act 1963. The concept of limitation is related with fixing or prescribing of a period of bearing the legal actions. The Limitation Act bars the legal actions by fixing a prescribed period of limitation. The delay defeats equity. Here there is a legal maxim: vigilantibus non dormantibus jura subvenient. It means the law assists those that are vigilant with their rights and not those that sleep thereupon. The Limitation Act relies upon this legal maxim, which means the law always supports those who are vigilant at their rights, but those who are asleep without caring about their rights. The limitation periods impose the time limits within which a party must bring a claim or give the notice of a claim to other party. They are imposed by a particular statute. Primarily, the statute is the Limitation Act 1963. Coming to the objective of Limitation Act 1963, the objective of the Act 1963 is understood with the help of this legal maxim: interest republicae at sit finis litium, which means in the interest of the state there must be an end to litigation. The limitation fixes such end to the litigation. The objective of the statutes of limitations to compel a person to exercise his rights of action within a reasonable time as to discourage and suppress stale, fake or fraudulent claims. It was held by the Honorable Supreme Court in AR 1972 SC 1935. In this case, the Supreme Court held that, the Orissa High Court held that the purpose of the statute of limitation is not to destroy the rights, but it is founded on the public policy fixing a lifespan for legal remedy for general welfare. Fixing a lifespan for legal remedy for the general welfare. It is the objective of Limitation Act 1963. Coming to the basic structure of Limitation Act 1963, Section 1 and 2 are the preliminary provisions. They explain about the extent and applicability and the definitions of few important words. The second part is related to limitation of suits, appeals and applications from sections 3 to 11. The third part is related to rules for computation of period of limitation from sections 12 to 24. The fourth part is related to acquisition of ownership by possession. Here sections 25 to 27 describe about the acquisition of ownership by possession. Sections 28 to 32 are the miscellaneous provisions in the Limitation Act 1963. Here the bar of limitation, suit against the trustee, closure of the court, delay condoned, legal disability, running of time and suits on foreign contract or comes under the second part in my video lecture. Exclusion of time in counting the period of limitation, effect of certain causes on period of limitation, the other rules related to the computation period of limitation are described in the third part of this video lecture, and the prescription easements and adverse possession are listed under the acquisition of ownership by possession in my video lecture. Along with these important 5 parts, preliminary provisions, limitation of suits, appeals and applications, rules for computation of period of limitation, acquisition of ownership by possession and miscellaneous provisions, there is a schedule in the Limitation Act 1963. The schedule comprises of 3 divisions: Division 1, Division 2 and Division 3. Division 1 is purely related to suits, the limitation period for suits from Articles 1 to 113. Division 2 in the schedule describes the limitation period for appeals from Articles 114 to 117. Division 3 of the schedule of the Limitation Act 1963 describes the limitation for various applications from Articles 118 to 137. There are 137 articles in the Limitation Act 1963 under 3 divisions in the schedule. Here the minimum limitation for the suits is 1 year and the maximum limitation for the suits is 30 years. The minimum limitation for the appeals is 30 days and the maximum limitation for the appeals is 90 days. Here, coming to the applications under Order 21 of CPC. Here these are the applications related to execution of the decree. Article 134, 135 and 136 describe the period of limitation for applications under Order 21 of CPC, that is for execution decree, application for execution of the decree. Here the other applications are described under Article 118 to 133. However, in the subsequent, in the further slides, I will explain the period of limitation with the help of a table. Now let us discuss the first part, that is the preliminary provisions. Section 1 and 2 of the Limitation Act 1963 explain the extent and important definitions. The Limitation Act 1963 extends to the whole of India except the state of Jammu and Kashmir. It is enumerated under Section 1 of the Act. The period of limitation means the period of limitation prescribed for any suit, appeal or application by the schedule according to Section 2. The prescribed period, here period of limitation prescribed for, here the word prescribed. The prescribed period means the period of limitation computed in accordance with the provisions of the Limitation Act 1963. The word prescribed period is defined under Section 2J of the Act 1963. Here the second part is related to the limitation of suits, appeals and applications. Section 3 to 11 are related to the limitation of suits, appeals and applications. Section 3 says that subject to the provisions contained in Section 4 to 24, every suit instituted, every appeal preferred and every application made after the prescribed period shall be dismissed. Here the suit includes plaint, pauper, claim against company, sit-off or counterclaim. Every suit, every appeal, every application which are made after the prescribed period shall be dismissed according to Section 3 of Limitation Act 1963. There is a section in Limitation Act 1963, that is Section 10. Section 10 gives an exception for bar of limitation under Section 3. The suits against trustees of Hindu, Muslim or Buddhist religious or charitable endowments. For the suits against trustees of Hindus, Muslims or Buddhist religious or charitable endowments, there is no bar of limitation. It is enumerated under Section 10. Here Section 10 is an exception to Section 3, that is bar of limitation. In various cases, the Supreme Court and several high courts held that the Limitation Act only bars the remedy and not the right. It bars the remedy but not the right. Coming to the second one, under Part 2, that is closure of court. Section 4 describes expiry of prescribed period when the court is closed. Where the prescribed period for any suit, appeal or application expires on a day when the court is closed, then the suit, appeal or application may be instituted on the day when the court reopens. For instance, in order to file a suit for declaration of ownership of certain immovable property, there is 3 years of limitation period prescribed under the Limitation Act 1963. 3 years is the limitation period in order to declare the ownership of certain property. For declarations, the 3 years is the limitation, the period of limitation. But this 3 years limitation expires on Sunday. On Sunday. But the Sunday is court holiday. The court is generally closed on Sundays. But there is a remedy for there is a remedy under such circumstances. Here the party can file the suit. The party can file the suit on Monday when the court reopens. Monday the court reopens. Hence the party can file the suit on Monday when the court reopens. The same principle applies to the public holidays, festivals, those and vacation, the court vacation. If the limitation expires on a day when the court is closed, then the suit, appeal or application may be instituted on the day when the court reopens. Coming to section 5, the section 5 is one of the crucial sections in Limitation Act 1963. Delay condoned is explained under section 5. It is also described in the act in another way: extension of prescribed period in certain cases, or extension of limitation period in certain circumstances. According to section 3, there is a bar of limitation. According to section 10, the bar of limitation does not apply on the trustees of Hindu, Muslim or Buddhist religious or charitable endowments. According to section 4, when the court is closed on a particular day, then the suit, appeal or application may be filed by the party on the day when the court reopens. According to section 5, the Limitation Act 1963 extends the limitation period. It is known as delay condoned or condonation of delay. Section 5. Section 5. Those who are practicing in civil side generally come across section 5 of the Limitation Act 1963. If the appellant in case of appeal or applicant in case of applications, if the appellant or applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application, may be admitted even after the prescribed period of limitation. Here, the essential ingredients of section 5 are sufficient cause, satisfies the court. Sufficient cause and satisfies the court. Here in AER 1994 SC 466 and in AER 2002 SC 2545, the Supreme Court held that the court must be satisfied with a sufficient cause for the delay. If the court is satisfied by the appellant or applicant, then it can be admitted even after the period of even after the period of limitation. In various cases, the Supreme Court and High Courts declared these as the sufficient causes. Illness is a sufficient cause, death of the blood related is a sufficient cause, loss of court documents is a sufficient cause, the solitary confinement of the party is a sufficient cause, the mistaken advice by the counsel is a sufficient cause. Under like sufficient causes, the appellant or applicant may be admitted even after the prescribed period of limitation. They can file an appeal or they can make an application even after the period of limitation if they satisfies the court with the sufficient causes. There are certain exceptions for section 5. Here the two words are used, appellant and applicant, appeal or application. Generally, the Limitation Act 1963 is applicable to all suits, appeals and applications, but section 5 is applicable to only the appeals and applications, the suits. For suits, section 5 is not applicable. Every suit should be instituted within the period of limitation. There is no extension of the limitation period for the suit. The second exception is application under any provision of Article 21 of CPC for execution applications. Section 5 is applicable to applications but not the execution applications. These two are the exceptions for section 5 of Limitation Act 1963. Next, the concept of legal disability is explained under section 6, 7 and 8 of Limitation Act 1963. The following persons are legally recognized as legally disabled persons under section 6 of the Act 1963. They are minor, insane and idiot. Minor, insane or idiot is generally considered as the persons with legal disability under section 6. Let us discuss the rules related to legal disability. What will happen to the period of limitation in case of legal disability? If there is one legal disability, they may institute a suit or make an application after the disability has ceased. Of the party, if the party is a minor, the minor may institute a suit or make an application after the minority has ceased, after the minor became the major. He can file a suit. Next, when there are two legal disabilities, the person is a minor and he is also an insane, or he is an idiot. He is a minor and he is an idiot. He is a minor or he is an insane. Under such circumstances, the person has two legal disabilities. After the both disabilities have ceased, after the minority ceased, after the minority is ceased, that means after he become major, it is expiry of one legal disability, and after expiry of his insanity, he can file a suit or he can file an application, he can make an application to the court. In case of legal disability up to the death, his LRs, his legal representative, the person who is legally disabled, in case such legal disability may extend up to the death of such person, under such circumstances, his LR, his legal representative, may institute the suit or make an application after the death of such person. This is third condition. Next, the fourth condition is legal disability to legal representative. Here, the party has legal disability under section 6. His LR is also has the same legal disability. Under such circumstances, where the LR at the date of death of the person whom he represents affected by any such disability, rule 1 and rule 2 shall apply. His legal LR has also the same legal disability. If his legal LR has one legal disability, after expiry of such one legal disability, he can file a suit. If the LR has two legal disabilities, after expiry of two legal disabilities, the LR can file the suit or make an application. This is condition number 4. Next, the death of the legal disabled person after disability expires, but within the date of limitation. Under these circumstances, his legal representative may institute the suit or make an application within the same period after the death. Within the same period after the death, his LR may institute the suit or make an application. These 4 conditions are prescribed under section 6 of the Act 1963. For the purpose of section 6, minor includes a child in womb. When there is no next friend, here the concept of next friend is enumerated under Order 32 of Civil Procedure Code 1908. When there is no next friend to the legally disabled person, or where the next friend himself is the wrongdoer, or where the next friend has not filed the suit under Order 32 of CPC, then the victim can invoke section 6 of the Limitation Act. This is the general rule related to section 6. Section 6 is also one of the most important sections in Limitation Act 1963. Section 6 to 8 are related to persons of legal disability or the concept of legal disability. Let us discuss the second section under legal disability, that is section 7. Legal disability of one of several persons. Where one of several persons jointly entitled to institute a suit or make an application for execution of a decree, under any such disability, where a discharge can be given without the concurrence of such person, the time will run against them all. Where no discharge can be given, time will not run against any of them until one of them becomes capable of giving such discharge without the concurrence of the others, or until the disability ceases. When the discharge can be given, then time will run against them all. Where no discharge can be given, the time will not run against any of them until one of them becomes capable of giving such discharge, or until the disability has expired. Section 8 describes special exceptions to legal disability. The parties who are specified under section 6 and 7 shall make the suit or application within 3 years from the expiry of the disability. from the cessation of the disability. The same rule is applicable in case of right of preemption. Here, after expiry, within 3 years from expiry of the disability, the party should make a suit, should institute a suit or make an application. This is specified under section 8 of the Act 1963. Next, running of time. Once the period of limitation starts, no subsequent disability or inability stops it. Once it is started, then there is no break. There is no break for stop. Once the period of limitation is initiated, once the period of limitation starts running, then there is no subsequent disability or inability stops it. Here, the next one is a suit on foreign contract. It is explained under section 11. Suits instituted on contracts in Jammu and Kashmir or in a foreign country shall be subject to the Limitation Act 1963. It is the end of part 2 in my video. Part 3 is related to rules for computation of period of limitation from sections 12 to 24. Here, the rules for computation of period of limitation is again divided into 3 subparts for understanding purpose. They are exclusion of time in counting the period of limitation, exclusion of time in counting the period of limitation from sections 9 to 15. Here the section 9 comes under part 2 as well as part 3. The first pair of section 9 is related to part 2. The second pair of section 9 is related to rules for computation of period of limitation. The effect of certain causes on period of limitation is explained under section 6 to 21. The other rules related to computation period of limitation are explained from section 22 to 24. Coming to the first one, under exclusion of time in counting the period of limitation, that is the presence of letter of administration under section 9 para 2, where the letters of administration, before going to discuss the ingredients of section 9, it is better to understand the concept of letters of administration. The letters of administrations are granted by the competent civil court to appoint an appropriate person to deal with the deceased person's estate, where the property will pass under intestacy rules. According to Schedule 7 of Indian Succession Act 1924, it is not Hindu succession, it is Indian Succession Act 25, an application can be made to the competent civil court within 14 days after the death of the person. On satisfaction, the court may grant the letters of administration. Let us discuss section 9, along with the ingredients of section 9. Where the letters of administration to the estate of a creditor have been granted to his debtor. Generally, the letters of administration are granted by the competent court in order to appoint a person to deal with the estate of the deceased person. Here, where the letters of administration to the estate of deceased person, here the estate of the deceased creditor have been granted to his debtor, the running of period of limitation for a suit to recover the debt shall be suspended while the letter of administration continues. Next, Section 12 of the Limitation Act describes exclusion of time in legal proceedings. It is also one of the most important sections in Limitation Act. In computing the period of limitation for any suit, appeal or application, the first day, the day of judgment, the time for obtaining a copy of decree, sentence or order, the time for obtaining a copy of award should be excluded. It's the rule under Section 12. The first day, the day from which such period is to be reckoned, should be excluded under Section 12, subsection 1. The day of judgment shall be excluded according to 12.2. The time for obtaining the copy of decree, sentence or order against which an appeal or application has to be filed shall be excluded under Section 12, subsection 2 and 3. The time for obtaining a copy of award against which an application to set aside an award shall be excluded according to Section 13.4. Just these four: the first day, the day of judgment, the time for obtaining the copy of decree, sentence or order, the time for obtaining a copy of award should be excluded according to Section 12 of Limitation Act 1963. Next, Section 13, exclusion of time in cases where leave to sue or appeal as pauper is applied for. In computing the period of limitation for any suit, appeal or application for leave to sue or appeal as a pauper has been made or rejected, a pauper suit has been made and the same is rejected by the court. A pauper appeal is made by a party and the same is rejected by the court. Under such circumstances, the time duration between the date when the pauper has been made and the date when it is rejected. When it is made, a pauper suit or pauper appeal is made, and when it is rejected, the time duration between these 2 points should be excluded according to Section 13. Next, Section 14, exclusion of time of proceeding bona fide in court without jurisdiction. Without jurisdiction, that is effect of bona fide litigation in the wrong court. In computing the period of limitation for any suit, appeal or application, the time spent by mistake or misunderstanding, in proceeding bona fide in the court without jurisdiction shall be excluded. The time spent by mistake in the court where there is no jurisdiction to entertain such suit or appeal or application, the time spent by misunderstanding of the parties or the court should be excluded according to Section 14 of Limitation Act 1963. Next, the other cases are specified under Section 15 of Limitation Act, that is exclusion of time in certain other cases. In computing the period of limitation for any suit, appeal or application, the time duration of the day on which the stay by injunction or order was issued and the day on which it was withdrawn. The day on which the stay was issued and the day on which it was withdrawn shall be excluded. If the consent or sanction of the government or some authority was required to be obtained for filing a suit, application or notice was required, if the consent or sanction of the government or some authority is required or notice was required to be given to the government in accordance with law. Under these two circumstances, the period spent in obtaining the consent or sanction, or the time in giving such notice, shall be excluded in order to file a suit. The consent of the government, if the consent of the government is required, then the time taken to obtain the consent from the government should be excluded. In order to file a suit, a notice should be given to the government. Under such circumstances, the time taken for giving the notice should be excluded. Under section 15(2), in a suit for possession by a purchaser at sale in execution of decree, purchaser at a sale in execution of decree, suit for possession by a purchaser at the sale in execution of a decree, the time during which a proceeding to set aside the sale has been prosecuted shall be excluded. The time during which a proceeding to set aside the sale, the time, if the court says set aside the sale, the time during which a proceeding to set aside the sale shall be excluded under section 15(4) of the Limitation Act 1963. In any suit, the time during which the defendant has been absent from India, if the defendant is not available, he is absent from India, it shall be excluded under section 15(5) of Limitation Act 1963. Next, this is the end of part 3. Sorry, A, subpart A under part 3 of this video. Next, B, effect of certain causes on period of limitation. First one is section 16, which describes about effect of death. Effect of death on or before the accrual of the right to sue. Where a person who would have a right to institute a suit or make an application dies before the right accrues. If a person dies before the right accrues to institute a suit or file an application, make an application, the period of limitation shall be computed from the time when there is a legal representative of the deceased capable of instituting such suit or making the application. If a person dies before the right accrues, under such circumstances, when the legal representative of the deceased person is capable of instituting such suit or application, from that point the limitation begins. Where a person against whom a right to institute suit or make an application would have accrued dies before the right accrues. Where a person who would have a right, it describes about the plaintiff. Where a person against whom, it is related to the defendant, the proposed defendant, the proposed plaintiff, it is related to the proposed defendant. The period of limitations shall be computed from the time when there is a legal representative of the deceased against whom, it denotes the proposed defendant, the plaintiff may institute the suit or make an application. There are certain exceptions to section 16. They are suit to enforce the right of preemption. The right here, these rules are not applicable in case of suit to enforce the right of preemption. The right of preemption is the right of first option to buy. For example, there is a site, this part of this land is related to Mr. A. Mr. B is the adjoining owner. this part of the land is belongs to Mr. B, or B is the owner of this part of land. The right of preemption means if A wants to sell his property, first A should give an opportunity, or A should give an option for B in order to buy such property. A first should give an option to B in order to buy such land because of the nature here. A and B are the adjoining owners. If B obtains A's land, it is easier for B in order to construct a building or to cultivate something in that land. Hence, if A wants to sell such property, he should give first option to B in order to purchase such land. This is known as right of preemption. Under such conditions, the suit to enforce right of preemption, these rules are not applicable. Suit for possession of immovable property, these principles are not applicable. The suit for hereditary office, these principles are not applicable. Next, the effect of mistake or fraud is explained under section 17. The period of limitation starts only after the fraud or mistake is discovered by affected party. Once the fraud or mistake is discovered by the affected party, then the period of limitation starts from that point. In case of a concealed document, when at the first time the concealed document is produced or compelled its production, from that point the limitation will be started. If the judgment debtor has prevented the execution of a decree or order by fraud or force within the period of limitation, the court may extend the period for execution of decree or order on application of the decree holder. The application to be made within 1 year from the date of discovery of fraud or the cessation of force, as the case may be. In this case, the Bombay High Court held that the limitation starts from the date of knowledge of mistake of law. It may be even 100 years from the date of payment. In this case, the Supreme Court 3-member bench held that the cardinal principle in section 17 is that fraud nullifies everything. Thus, appeal against the party can be admitted beyond limitation if party has committed the fraud. There are certain exceptions for section 17. On the basis of the ingredients of section 17, the limitations, the period of computation of limitation starts only after the fraud is discovered by the affected party, only after the mistake is discovered by the affected party, only the first time when the concealed document is produced. In case of the concealed document, from that point the period of limitation will be started. There are certain exceptions to section 17, that is for fraud or mistake. In case of fraud, there is an exception. Any property purchased for valuable consideration by the person who is not a party to the fraud, and at the time of purchase he did not know that any fraud had been committed. He is not a party to the fraud, and at the time of purchase he did not know that any fraud had been committed. Then the rule section 17 does not apply. In case of mistake, any property purchased for valuable consideration by mistake, at the time of purchase, if he did not know that any mistake had been committed, by mistake he purchased some property for valuable consideration, and at the time of such purchase he did not know that any mistake had been committed, then section 17 does not apply. In case of concealed document, any property purchased for valuable consideration by a person who is not a party to the concealed document, who is not a party to the concealment, and at the time of purchase, if he did not know that the document had been concealed, then 17 does not apply at all. Next, section 18 of the Act 1963. Effect of acknowledgement in writing. Here, acknowledgement means admission of an existing monetary or non-monetary liability of a person. If a person admitted that I am liable to pay 1 lakh rupees to Mr. B, if A admitted that I am liable to pay 1 lakh rupees to Mr. B, it is said to be an acknowledgement. What will be the effect of acknowledgement in writing is explained under section 18 of the Act 1963. If the acknowledgement of any property, right or liability is obtained in writing, duly signed by the party, acknowledgement should be in writing, and such acknowledgement should be duly signed by the party against whom such property, right or liability is claimed. Before the expiration of the period of limitation, a fresh period of limitation is computed from the date of acknowledgement. A person has taken loan, Mr. A has taken loan from Mr. B. A has taken the loan from Mr. B. The amount of loan is 10,000 rupees, 10k. A received 10,000 rupees from Mr. B in 2009. In 2011, Mr. A acknowledged in writing and he affixed his signature that he has taken some money. He has taken 10,000 rupees from Mr. B with the help of an acknowledgement in the year 2011. Then the period of limitation starts from 2011, not from 2009. A fresh limitation is starts a fresh period of limitation is computed from the date of acknowledgement. Then acknowledgement can be signed either personally or by agent duly authorized on his behalf. Next, payment of debt or interest, that is effect of payment of debt or interest. This is a payment of debt or interest in section 19. If payment on account of debt or of interest on a legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized this behalf, in this behalf, a fresh period of limitation shall be computed from the time when the payment was made. When the payment was made, from that point, a fresh period of limitation will be started. Where a mortgaged land is in the possession of the mortgagee, mortgaged land is in the possession of mortgagee, not in the possession of mortgager. It is in the possession of mortgagee, the transferee, the receiver. The receipt of the rent or produce of such land shall be deemed to be a payment. In case of the word payment, debt does not include money payable under the decree or order of the court. These are the other ingredients. Here we need to remember only this point, that is, a fresh period of limitation shall be computed from the time when the payment was made by the party or the party who is authorized on this behalf. Next, section 20 of Limitation Act. This is not effect of acknowledgement. Acknowledgement or payment by another person. The expression agent duly authorized in this behalf in section 18 and section 19 shall in the case of a person under disability. It includes, if a person is under a disability, then an agent duly authorized in this behalf, this word is used in section 18 and 19. When a person is under a disability, then an agent duly authorized in this behalf can make the acknowledgement or he can make the payment. Here the agent duly authorized in this behalf includes lawful guardian, committee or manager or an agent duly authorized by such guardian, the lawful guardian, or a committee authorized by the guardian, a manager authorized by the guardian, an agent authorized by the guardian. Here the guardian is an agent authorized on behalf of the person under disability. Here the guardian is an agent for a party. The guardian can also authorize another person in order to give certain acknowledgement or payment. Committee manager to sign the acknowledgement or make the payment. Here there are certain exceptions for section 20. They are, one of the several joint contractors are not treated as agent duly authorized in this behalf. The partners are not treated as agent duly authorized in this behalf. The executors, the mortgagees, chargeable by the reason only of writing acknowledgement signed by or on or of a payment made by or by the agent of any other or others of them. The joint contractors, partners, executors, mortgagees are not treated as the agent duly authorized in this behalf under section 20. Next, section 21 describes about effect of substituting or adding new plaintiff or new defendant. Substituting a new plaintiff in the place of the old plaintiff, adding a new plaintiff, substituting a new defendant in the place of old defendant, or adding a new defendant. The effect of these circumstances is explained under section 21 of the Limitation Act 1923. If after the institution of a suit a new plaintiff or defendant is substituted or added, after the institution of a suit a new plaintiff is added or a new defendant is added or a new plaintiff is substituted or a new defendant is substituted, the suit shall be deemed to have been instituted when he was so made a party. The period of computation starts from when he was so made a party. If the court is satisfied that the omission to include a new plaintiff or defendant was due to a mistake made in good faith, it may direct that the suit shall be deemed to have been instituted on any earlier date. There are certain exceptions to section 21. Section 21 subsection 1 says that section 21 subsection 1. Section 1 subsection 1 shall not apply to a case where a party is added or substituted owing to assignment or devolution of any interest during the pendency of a suit, or where a plaintiff is made a defendant or a defendant is made a plaintiff. Under these circumstances, it is not applicable under section. These are the exceptions for section 21. Next, C under part 3 of this video lecture. Continuous breaches and torts. In case of continuous breach of contract or tort, a fresh period of limitation begins to run at every moment of time during which a breach or tort continues. A continuous breach. At every breach, a fresh period of limitation begins to run. At every breach of tort, a fresh period of limitation begins to run. At every breach of contract, a fresh period of limitation begins to run, according to section 25. Next, suits for compensation for acts not actionable without special damage. In case of a suit for compensation for an act which does not give rise to a cause of action unless some specified injury actually results therefrom, the period of limitation shall be computed from the time when the injury results. When the injury results, from that point the period of limitation shall be computed. Next, the computation of time mentioned in instruments is explained under section 24. It is a general rule related to computation of period of limitation. All the instruments shall, for the purpose of the Limitation Act 1963, be deemed to be made with reference to the Gregorian calendar. The Gregorian calendar. For the purpose of period of limitation, for computing, for starting point, for ending point, the Gregorian calendar should be considered. They should refer the Gregorian calendar. It is legally enforced under section 24 of Limitation Act 1963. Next, part 4, that is acquisition of ownership by possession. Sections 25, 27 and 29 subsection 4 are related to acquisition of ownership by possession. Section 25, 26, 27 and 29 subsection 4 are identical with section 15, 16 and 17 of Indian Easements Act 1982. These describe easement by prescription. Section 15, 16 and 17 of Indian Easements Act 1882 describe about easement by prescription. The sections 25, 26, 27 and 29(4) are related to the easement by prescription. Coming to section 25, acquisition of easement by prescription. Acquisition of easement by prescription is explained under section 25. In case of access and use of access and use of light or air for any building. The claimed right to access and use of light or air has been enjoyed for 20 years as an easement as of right without interruption by any person, then such right is treated as easement, and such easement is absolute and final. In case of access and use of light and air, if a person continuously enjoyed the access and use of light or air for 20 years as an easement and as of right without any interruption by any person, then it is said to be easement by prescription. This easement by prescription shall be absolute and final. Here, the claimed right, if the claimed right is related to government property, then we need to substitute the words 20 years with 30 years. In case of government property, the person should enjoy continuously for a period of 30 years. It is specified under section 25 subsection 2 of the Limitation Act 1963. As an easement as of right without interruption, if any person enjoyed the government property for 30 years, then the easement shall be absolute and final. Coming to this part, in case of access and use of, here this is light or air, this is access and use of way, passage, water course, use of water or any other easement. In case of light and air, these principles are applicable. In case of use of way, passage, water course, use of water or other easements, these principles are applicable. The claimed right has been enjoyed for 20 years as an easement as of right without interruption, peacefully and openly by any person, then the easement shall be absolute and final. If any person openly, peacefully, without interruption, as of right, as an easement, claimed the right and enjoyed for 30 years in case of government property, then such easement shall be absolute and final. If the claimed right has been enjoyed for 20 years, it is easement, that easement shall be absolute and final. If the property is government's property, if he enjoyed the claimed right for 30 years, then such easement shall be absolute and final. Here we need to remember one principle, that is the period of 20 years expires within 2 years of filing of the suit. The period of 20 years shall be taken to be a period of ending within 2 years next before the institution of the suit, according to section 25(2). It means that if a person has been enjoying a particular property from 1989 to 2009, it is a period of 20 years. If the owner of such property, here he is not the owner, he has been as of right, as of easement without interruption, he has been enjoying certain property from 1989 to 2009. It is a period of 20 years. If the true owner, the real owner of such property files a suit for possession in 2010, his right of easement will be expired. If the true owner files a suit for the possession of such land in 2011, there is no easement right for the adverse possessor. If the true owner files the suit for possession of such property in 2012, then there is no remedy. Then there is no remedy for true owner. The true owner should wake up within these 20 years from 1982 to 2009, or plus within 2 years, that is within 2011. This is the grace period. He must file a suit for possession of such property within 2011. If he files the suit after 2011, then he can't get the possession of such property. The adverse possessor will get the easement rights over such property. This is the meaning of section 25 subclass 2. The same principle is also applicable in case of government property. 30 years plus 2 years, 20 years plus 2 years in case of other property, 30 years plus 2 years in case of government property. Next, acquisition of ownership by possession. Under this one, exclusion in favor of reversioner or servient tenement. Any easement by virtue of any interest for life or in terms of years exceeding 3 years, the time for enjoyment is of such easement during the continuance of such interest or term shall be excluded in computation of the period of 20 years. That means that period is not treated as easement. In case any easement by virtue, any interest or life, any interest for life or terms of years exceeding 3 years. Next, extinguishment of right to property is explained under section 26. If a party fails to institute a suit for possession of any property within the specified period of limitation under this act, his right to such property shall be extinguished. It is the actual section which describes about adverse possession, section 27, not 26, it is section 27. Next, section 29(4) describes that. Section 2(f) defines the word easement. Section 25 and 26 are related to easement. These shall not apply to the territories to which Indian Easement Act 1982 applies. See Article 64, 65 and 66 for more details related to acquisition of ownership by possession. Next, the miscellaneous provisions under the Act 1963. The Limitation Act 1963 shall not affect Section 25 of Indian Contract Act. The Limitation Act shall not apply to any suit or other proceedings under any law with respect to marriage and divorce. The Indian Limitation Act 1908 is hereby repealed under section 32. Next, let us have a quick look on important points to remember with regard to the Limitation Act 1963. Here, these are the most important points to remember in order to assess even without opening the bare act of the Limitation Act 1963. There are three divisions in schedule of the Limitation Act 1963. They are Division 1, Division 2, Division 3. Division 1 is related to period of limitation in case of suits. Division 2 describes about period of limitation in case of appeals. The limitation for appeals is described under division 3. Remember this point. The period of limitation for suits is always in years. The minimum period of limitation is 1 year and maximum period of limitation is 30 years. For suits, the period of limitation is always in years. For appeals, the period of limitation is always in months. 30 days is 1 month, 60 days is 2 months, 90 days means 3 months. 1 month, 2 months, 3 months. 30 days, 60 days and 90 days. Generally, in Limitation Act 1963, the days are used. But remember this point, always the period of limitation for appeals is represented in terms of months. For suits, in years. For applications, it is always in days, except for applications under Order 21 of CPC, that is application for execution of a decree. For all the applications, the period of limitation is always in days. The minimum 10 days, the maximum is 12 years. 12 years. For appeals, 30 days minimum, 90 days maximum. Here, remember these points. Suits related to accounts, contracts, declarations, mobile property, set aside decrees, instruments. For the suits related to any of these, the period of limitation is always 3 years. Contract, declaration, mobile property, set aside decree, instrument, account. The period of limitation is 3 years. Suits related to immobile property, the maximum period of limitation is specified, it is fixed only for suits related to immobile property. Minimum is 3 years and maximum is 30 years. Just go through the schedule of Limitation Act 1963 for elaborate period of limitation for various kinds of suits related to immobile property. Next, for the period of limitation for suits related to torts, minimum 1 year and maximum 3 years. The suits related to trusts and trust property, minimum 3 years, maximum 12 years. Here, this is the important point. Suits for which there is no prescribed period of limitation. If the period of limitation is not prescribed for any suit, then the period of limitation is to be considered as 3 years. If there is no period of limitation specified in Limitation Act 1963, then you can fix 3 years as period of limitation. Let us discuss for the period of limitation for appeals, for applications. The period of limitation for execution applications is minimum 1 year and maximum 12 years. The period of limitation for applications in specified cases other than applications under Order 21 of CPC, minimum 10 days and maximum 90 days. The minimum throughout the Limitation Act is 10 days. Minimum period of limitation in throughout the Limitation Act 1963 is 10 days and maximum is 30 days. In case of applications, minimum is 10 days and maximum is 90 days. In case of applications other than execution applications. For applications, it is also most important point. For applications for which no limitation is specified, then you can fix the period of limitation for such application as 3 years. Next, the important points to remember. Further, the important points to remember. The Limitation Act 1963 and CRPC. Limitation Act and CRPC. Limitation Act and CPC. Let us discuss few important points related to the relationship between Limitation Act and CRPC, the Limitation Act and CPC. For an appeal from sentence of death passed by Court of Sessions or High Court in the exercise of its original jurisdiction, the period of limitation is 30 days. For an appeal from any other sentence or order not being an order of acquittal, the period of limitation is 60 days under CRPC as well as under Limitation Act 1963. These provisions are similar. For an appeal to High Court, the period of limitation is 60 days. For an appeal to other court, the period of limitation is 30 days. Here the Limitation Act 1963 and CPC. For an appeal to a High Court from any decree or order, the period of limitation is 90 days. For an appeal to any other court for any decree or order, 30 days. For High Court, 90 days. From any court to High Court, 90 days. For any other court other than High Court, 30 days. For an appeal from a decree or order from order of any High Court to the same High Court, 90 days. 30 days. Next, the last but not least, this is not at all prescribed under Limitation Act 1963. The limitation for cognizance of offences is prescribed under Code of Criminal Procedure 1973 under section 468 of under 468. Court cannot take the cognizance of offence after expiry of the following limitation period: 6 months if the offence is punishable only with fine. If the punishment for an offence is only with fine, then the court take the cognizance of such offence within 6 months. The court cannot take the cognizance of the offence which is punishable only with fine after 6 months. If the offence is punishable with imprisonment for term not exceeding 1 year, the court can take the cognizance within 1 year. After 1 year, the court cannot take the cognizance of such offence. If the offence is punishable with imprisonment for a term exceeding 3 years, even the life imprisonment and the death sentence, the capital punishment, the court can take the cognizance if the offence is punishable with imprisonment for a term not exceeding 3 years, if the punishment is within 3 years and above 1 year, then the court can take the cognizance of such offence within 3 years. After 3 years, the court cannot take the cognizance of the offence. In case of economic offences, there is no time limit. In case of any offences which are punishable, in case of any other offences which are punishable with imprisonment more than 3 years, life imprisonment and capital punishment, the court can take the cognizance of offence at any time. For economic offences, the court can take the cognizance of offence at any time, even after expiry of the limitation period. Here there is no period of limitation at all. Thank you, friends. For more queries, you can contact me with this email ID. If you want to get the PDF form of this video lecture, you can get the slides of all my videos using this link. Thank you and goodbye.